All right, so hello, my name is Ayman Fadl, and welcome to the attendees in person. Welcome to the attendees remote. I am the vice president of the Central Savannah River chapter of Americans United for Separation of Church and State, which is based in Augusta, Georgia. We are at the headquarters library of the Augusta, Georgia Regional Library System on Telfair Street. Welcome, and we welcome especially to our remote attendees. Thank you very much from wherever you're dialing in from. Our guest today is Nick, and help me with the Nartowicz. Is that how you say it?
Nartowicz.
Nartowicz. Okay. All right. Excellent. Well, Nick. Okay. So on our literature, we had wonderful credentials for Nick. So I'm gonna at least kind of read them to you. That Nick joined Americans United for Separation of Church and State in 2017. And as state policy counsel, Nick tracks and analyzes state legislation that would affect church-state separation and religious liberty. He drafts letters to state legislators and works with allies to defeat bills that would undermine religious freedom. He joined Americans United after working for 2 years for Washington, D.C. Mayor Muriel Bowser in the Office of Federal and Regional Affairs. And as policy counsel, he worked with Congress and federal agency to advance D.C.'s priorities in judiciary, legal, public safety, LGBTQ, and technology issues. He also helped lead the district's successful 2016 statehood referendum. We're very happy that Nick agreed to do this program for us today.
To be able to do that. So first, I just want to say thank you for having me. I'm happy to be here and talk to you all. I do have a particular affinity for the region, having gone to high school in Hilton Head, South Carolina, where my mom still lives. So, Savannah River area is a place I love.
There we go.
So happy to be here with you all and talking about the state legislative outcomes this year in Georgia and South Carolina, which for the most part were actually pretty favorable for our issues. So first, the thing I'm going to share my screen for, I did put in a link for those of you who are on the actual Zoom, and I just emailed it to Eamon for the people who are in the room, but I've created a little report of the bills that we're tracking, which I'm going to share right now. And so this is a report created from the bill tracker that we use. So for a little bit more information, I am the only state policy counsel at Americans United, which means I am solely responsible for tracking the bills in all 50 states, which amounts to about 1,500 bills a year, which is a lot. Luckily, a lot of those bills don't move, and as we'll see as we go through this report a little bit. But one of the things that happens here is, like I said, we really only engage with the bills that are moving, and we do have a lot of bills that we classify. So I'm going to go through what's here. And you can see actually that this year, so this legislative year, there were 12 bills that were introduced, which didn't go anywhere. Those are actually the bills in South Carolina. They're not marked as dead yet, even though the legislature has adjourned. 10 bills that have failed, those are the ones in Georgia. 4, again, those are the considering South Carolina, and only 3 that became law. So you can see here, for the most part, the bills that we track are bills that we oppose. There are not many bills that are positive that we support. So it is a lot of opposing bills that are bad instead of actually helping to support bills that are good. So you can see in this next section the number of bills per issue. So we really have a number of buckets where we consider bills. The biggest one this year in these 2 states, as well as across the country, has been religion in public schools. Then there's using religion to discriminate, and vouchers, which are generally the 3 biggest categories we have across the country as well. There are a couple of other categories there, which I'm happy to talk more about if people have specific questions, but I'm not planning to address them specifically today. So again, this map obviously just shows what's happening in Georgia and South Carolina. And then at the bottom is a list of all of the bills that we are tracking. So again, if you are on the Zoom, you have access to that. If you are in the room, I'm sorry, we don't have direct access to it. I did, like I said, share the link with Eamon, and you can get it. I do ask that you don't share this out publicly. This does have a little bit more detail than we usually make public on our bills, because I wanted you all to see the categories and things. That a lot of that is internal just for the way that we track it, and not things that we make public, including the priority levels and things like that. So if you are on here, please use this. You can look at the bills, but don't share this outside of people who are AU members or supporters. not something that we want going wide. There's no particular harm. It's just something that we don't, it is kind of proprietary information such as it is that we don't share. So I'm going to go run through some of the bills that were really big highlights this year in the legislative session. The first of which is a voucher bill in South Carolina. So Americans United was actually founded more than 75 years ago to oppose private school vouchers. And when I tell a lot of people that, they don't realize how vouchers relate to religious freedom and the separation of church and state. But a fundamental principle of religious freedom is that you can't force someone to pay for someone else's religious education. That is a basic tenet of religious freedom, a basic tenet of our Constitution. And that's exactly what vouchers do. The vouchers in this country primarily go to religious schools. Religious schools make up the majority of private schools in the country. And across the country, it's something like 75 to 80% of voucher money goes to private schools. There are some states, in specific states, where it's upwards of 90%, or even some states where every single school that participates in a voucher program is a religious school. So although vouchers are not inherently religious, they do primarily fund religious education and religious schools. Those schools are also allowed to discriminate based on religion. So that includes not only refusing to admit or being able to refuse students who aren't the same religion of the school, but also to discriminate on religious beliefs. So if you are a Catholic school and you don't want to admit a student because their parents are LGBTQ, or you don't want to admit a pregnant teenager, or you want to expel a pregnant teenager, you can do that, and you're still getting state funds to do that. So it's state-funded discrimination as well. In addition to a whole host of other reasons that we oppose vouchers, which include that they don't improve student outcomes, they drain money from public schools, they don't actually work, they don't improve student achievement. So we do a lot of work on vouchers, and we actually also help run the National Coalition for Public Education, which is a coalition of national groups that fights vouchers on the national stage. But a lot of that work that we do is used to support work in the states to fight vouchers. So what happened in Georgia this year? Georgia has been trying to pass a kind of essentially a statewide voucher bill for a while. There are two existing voucher programs, one of which is focused on students with disabilities, and one is, I believe it's low-income students is the other one. But there's been a big push across the country, especially the last 3 years, to really pass basically statewide voucher programs. So programs that will eventually let every student in the state become eligible for the voucher program. And so we put in a lot of work fighting it. There are a lot of groups that were fighting this on the ground. We have a lot of resources through NCPE that we shared. But the bill did unfortunately become law. It made a lot of news when it happened. There was kind of tight votes around it. And so it creates a voucher that's eligible to any student who is zoned for a school that ranks in the bottom 25% of the Georgia Department of College Readiness. So basically that department creates a ranking of schools, and the schools in the bottom 25%, if you are zoned to go to that school, you're eligible to receive a voucher. So that might in general sound like a good thing, right? Students who are in this bottom 25% want to get a voucher to go to private school. Why is that bad? Well, first of all, you just have to be zoned to go to the school. It doesn't mean you have to actually attend that school. So if you are a family that lives in an area that is zoned to that school, and you are wealthy enough to afford to send your kid to a private school, and you do in fact send your child to a private school, regardless of how expensive or fancy it is, you are eligible to receive this voucher. So that's going to drain money away from the public schools and send it to wealthy parents who are already sending their kids to private school. I don't like it because it doesn't include a maximum income limit. The other thing we see is when these voucher programs get enacted, if they're not already statewide programs, they just get pushed to be bigger and bigger programs. So while it's only 25% this year, next year it might be up to 50%, right? The bottom 50%. And then in 3 or 4 years, they've expanded the program, and suddenly every student in the state is eligible for a program. And so it's all the reasons that I said that we oppose vouchers, though, right? That just gets bigger and bigger as more students become eligible and are able to take advantage. But what we've really seen with the explosion of statewide programs is how much voucher programs actually fund wealthy people already. So in states like Arizona, there are no caps on it. And so the majority of people taking advantage of the voucher are people whose kids are already in private school. So they're already able to afford it, and they're basically just getting free tax money to pay for their kids' tuition to go to private school. Because even if you can afford it, why not get that $6,000, $10,000, whatever the amount is, to skim off the top of your child's tuition and get free money from the government, essentially. So it's not actually helping students who are in these schools necessarily, because it's going to go primarily to the students who are already able to afford private school. And directly to the point of seeing expansions of vouchers, South Carolina, while they didn't pass a bill this year, there was a bill that was enacted last year to create a new voucher program that was essentially it's a limited program right now. And that bill has been challenged. Luckily, we've got a good Supreme Court decision on a similar related voucher issue after the pandemic. Basically, the state Supreme Court said that the state constitution prohibits a voucher program from existing. And so this program, the program that passed last year, is being challenged in South Carolina, which is great. I'm very hopeful for a good outcome. But despite that ongoing case, legislators this year actually introduced a bill to already expand the voucher, right? The bill passed last year, they created this voucher, and this year they already were looking to expand it. That means they had no time to figure out how it was working, whether kids were benefiting from it, whether kids were improving in their academics. They had no information, and they already were planning to expand it because it's not actually about helping students in public schools. It's just about fighting to privatize education, right? The ultimate goal of vouchers is to just take that pot of money that is public education and privatize it, to send it to private schools, which, as I said, are primarily religious. So luckily that South Carolina bill didn't actually pass. It did pass the House pretty easily and pretty quickly. I think the vote was something like 69 to 32, but it was never picked up in the House, or I'm sorry, in the Senate. So that bill is dead for now. But of course, we also know that a bill dying this year doesn't mean it will never come back. I'm sure there will be a renewed push for that bill next year in legislative session. So I'm talked a lot about vouchers. I'm going to actually stop here and see if there are any kind of specific questions about vouchers, any of those bills that I can address before I move on to the next topic, whether it's from someone on the Zoom or in the room.
Okay, so there's no questions. And by the way, I should have mentioned this. We have a question and answer panel for those participating remotely. So please type in your question into the questions for those who are remotely attending. Does anybody physically attending have a question for Nick?
I'm relatively new to the concept of vouchers. I thought they kind of were connected to charter schools, but that's two separate issues, right?
Nick, were you able to hear the question?
Yes. So just in case for those who couldn't hear it, so the question was relatively new to the idea of vouchers and how are they connected to charter schools? Great question, and actually something that we get all the time. I will say something about vouchers, and people will say, "Oh yeah, I don't like charter schools," and they are actually different issues but related. So charter schools are a version of public schools, right? You have your kind of traditional neighborhood public school that everyone knows, the school that you live near, are zoned to go to, and you attend that school. Charter schools were kind of an alternative public schooling method. And so the way charter schools work is the government essentially gives a charter to, often it's a private organization. Sometimes they work with colleges or nonprofits, but that charter is granted to an organization that runs the school kind of independently of a lot of state oversight. There is still minimal state oversight or some types of state oversight in terms of having to take tests, and they have to be non-discriminatory in certain ways. But charter schools are kind of if you've heard of a magnet school, it's kind of like that. It's very similar to that idea where they basically get a certain selection of students. Often you have to apply to get into a charter school, and it might be a random application. It's a lottery or something like that, but there is some sort of application process to get into a charter school. It's not just you live near it and you go there. They also often try different things with curriculum and things like that. So there's a lot of independence, but they are still fundamentally public schools. So for a long time, AU didn't take a position on charter schools, and as an entity, we still do not take a position on charter schools, whether or not they should exist, because that's a separate policy question from the religious issue. Because as charter schools, or as public schools, charter schools are still not allowed to promote religion or teach a religious curriculum, right? They're subject to the same constitutional requirements about education that traditional public schools are. Vouchers are an entirely separate entity wherein you take taxpayer money and it goes to private religious schools. They take a lot of different forms. There's a traditional voucher, which is just you have that voucher and the state gives the funding directly to the private school. But after a round of decisions that basically in a lot of states said that is unconstitutional because there are state constitutional provisions that protect religious freedom and say you can't fund someone's religious education. 40 some odd states have a version of that provision. They created different concepts of vouchers. And so the two big types are education savings accounts and tuition tax credits. So education savings accounts, or ESAs, basically what happens there is the state says, okay, here's a pot of money. It's $6,000. That's a pretty standard amount. And the person receiving the voucher or the family receiving the voucher can use that $6,000 for anything from a list of approved expenses. At the top of the list, of course, is tuition at a private school. So, right, so that's what most people who get a voucher will use it for. But you can also use it for things like books, which is pretty reasonable. But then there's really a long list of other educational materials. And so we've seen in some states, like Arizona is, again, a great example of this, where people have gotten approved to buy trampolines, which they allege are education or exercise. They've gotten to buy Legos and like expensive Legos, like $500 plus Legos. Legos have gotten extremely expensive if you've not looked at the price of Legos in a long time. And so they can just basically buy anything they want that has some sort that they claim has an educational value. And there are guidelines, but they're usually pretty wide and pretty broad because they don't want oversight in these programs. And so, but you just basically get like a debit card essentially that you can use to pay for things up to the amount that the voucher is. TTCs or tuition tax credits are another version of that. And what happens there is essentially the government creates a program that says, okay, you can donate to a scholarship granting organization. So if I'm a big business, I can donate, say, $1 million to the scholarship granting organization. And what happens is that that organization then gives out vouchers to families. And again, they can use it to pay for tuition. Sometimes they do have those broader categories that they can use it for, but primarily it goes to tuition. So that exists separately. But then what happens is once I, as the big business, file my taxes, I say I gave $1 million, and then I can get a dollar for dollar tax credit back on my taxes. So if I owe taxes, I take $1 million off the top. Even if I don't owe any taxes, I am not an accountant, I'm a lawyer, so I don't know how this works. But say you engage in some tax wizardry and you as a corporation, you owe no taxes, you would still get that $1 million back because it is a tax credit, right? So I, as the company, don't actually donate anything. The government just, I give the money to the scholarship granting organization, then the government gives me that money back. So it's just basically a pass through for the government to pay for it. And those systems were created to get around those no aid clauses that are in states, because then what happens is it's not the government giving the money to the school. The government gives the money to the parent or to the scholarship organization who gives it to the parent, and then the parent makes that choice. So my joke there is that's why people hate lawyers, right? It's like they found a way to get around the very plain language about what you are not allowed to do with voucher money and make it work anyway. So like I said, those are, that's kind of the difference between vouchers and charter schools. Charter schools are public and vouchers are all about private schools and funding that. Okay, and so I see a chat or a question in the chat about Ten Commandments and Bibles in classrooms, which is the next section that is on my agenda here is religion in public schools. And so the question in the chat for those who can't see is anything to indicate that the recent Ten Commandments in Louisiana and Bible in classrooms in Oklahoma legislation directives will surface in Georgia and or South Carolina. So the short answer is yes, because both Georgia and South Carolina had Ten Commandments bills introduced this legislative session. Luckily, neither of them passed. The South Carolina bill actually didn't, I think, even get a hearing. And so for those who don't know, what happened last year in Texas is Texas introduced a bill that would require every single public school to post the 10 Commandments in every single classroom in the state. That is blatantly unconstitutional. So that bill luckily did not pass in Texas, but we did see it replicated in a number of states. I want to say it was 6 other states this year. South Carolina and Georgia are 2 of them. And it actually passed in Louisiana this year. AU has filed a lawsuit alongside the ACLU of Louisiana, and the Freedom from Religion Foundation. And we are being assisted by Simpson, Thatcher, and Bartlett as pro bono counsel in that. And so we are challenging that law, right? We are suing to overturn it. We represent a number of parents. I want to say it's 9 families, a number of whom are faith leaders, and all of whom are people of. Oh, no, it's not true. I'm sorry. Most of whom are people of faith. I think there is one family that is atheist and or non-believer. I don't remember exactly how they identify. And so we are suing to overturn, to both get a preliminary injunction to stop the law from taking effect, because it would take effect at the start of this new school year, and to stop the law from taking effect at all, right, to overturn the law. So we do definitely expect to see this happen in a number of other states now that it's passed in Louisiana. A lot of times it really does take that first state to really break the dam. So it was a little bit surprising to me that South Carolina did not actually have a hearing on the bill once it failed in Texas, and certainly once it started to pick up steam in Louisiana. I was really expecting that to come up. Luckily, like I said, it did not. In Georgia, it did get a hearing, but it didn't actually get out of committee. So we worked in Georgia. We worked with the ACLU of Georgia to prep them, and I know there was a hearing there that they testified at. So it's definitely something that we expect to come back, and we will be ready to fight it and to support our in-state allies who are doing the work on the ground in fighting that, because that is something that is really, I mean, I will say, frankly, really scares me, right? There is a 44-year-old precedent saying that you cannot display the Ten Commandments in public schools, and this is not only a direct challenge to that, but is designed to overturn that decision. So seeing that is something that is really concerning to me. We've seen a lot of this of state legislators trying to figure out what precedents exist that have been longstanding broadly, but especially in the church-state realm, and figuring out ways to directly challenge them. And it is only going to get worse if my predictions hold up. So we definitely expect to see more of that, and for these bills to come back next year in both Georgia and South Carolina. Another bill that happened in Georgia was a chaplain's bill. For those of you who might have seen, there's been a lot of news about that. Texas again led the way. And alongside their efforts to pass the Ten Commandments bill, they passed a bill that actually allows public schools to have chaplains volunteer or be hired in the school to provide services to students. This year we saw that was actually where we really saw the explosion of those bills. We were tracking bills in 15 different states this year. Georgia was one of them. So far, only 2 of them have actually been enacted in Florida and Louisiana, which is great. We did a lot of work on that in general. We actually worked with a broad coalition of national groups that includes groups like the ACLU, FFRF, a lot of faith groups, Baptist, like the Baptist Joint Commission for Religious Liberty, or committee, I never remember what the C is in BJC. The Interfaith Alliance, National Council for Jewish Women. We worked with education groups. And so through that group, we actually helped put out 3 different letters, one of which came from, I think the number is now up to 300 chaplains from across the country who oppose these bills. One is signed by 38 religious or organizations affiliated with religious organizations or denominations, and then one that AU signed by 34 total civil rights and education organizations opposing these bills. And so working with that coalition to release those letters, and we've really been using those in states to fight back against these bills and show why they're a bad idea. But again, we do expect to see many of these coming back. And then the quick last one that was mentioned in that first comment was the Oklahoma directive. So again, you might have seen the news of the Oklahoma Superintendent of Public Instruction, Ryan Walters, who is, I like to consider, my arch nemesis in the church-state public education world, because he does a lot to be essentially just to make news. But 3 weeks ago now, it was on a Thursday, I do remember, so I think it's 2 weeks tomorrow. He released a directive directing every school in the state, or saying what he announced publicly was that every school in the state would have to have a Bible in every classroom and that they would teach from the Bible. What the directive actually says is that teachers in 5th grades and above, when appropriate, should use the Bible to essentially help with lessons, right? So there are actually ways under the law that you can constitutionally teach about the Bible. The Bible can be used, but this is based on Supreme Court precedent. The Bible can be used to teach about literature, art history. There's kind of there are lots of ways where the Bible permeates what happens in our world, or even history, right? So what you can do is, if you are in a literature class and you're reading a Shakespeare play and there is an allusion to a biblical reference, you can talk about that biblical reference and what it means and why people would have known it and what the point is that it makes in the play. If you are studying Renaissance painting, a lot of that is about the Catholic Church and Catholic religion. You can talk about how the Bible influences specific paintings or what was happening, what was going on at the time. If you are talking about the Crusades and history, or expansion of Europe, or what's happening in Europe and the Holy Roman Wars, right? Like, you can talk about how the Bible influenced those things, or you can talk about schisms between religions, right? And how that influenced Europe again, and what was going on, and what the arguments were over the specific provisions of religion that were being disputed at the time. What you can't do is teach that the Bible is real, literal real and literal, or that it is actually history, right? That the things in the Bible actually happened. And the way we summarize it is you can teach about religion, but you can't teach religion. So basically what Superintendent Walters did was try to walk that line and make it seem like he was saying you had to teach religion, when really the language of the directive hews pretty close to what is constitutionally allowed. So we are keeping an eye on that and going to, if it is implemented in a way, if there's more guidance that's given that is unconstitutional or directs teachers or schools to engage in unconstitutional practice, we will follow up with that. As to whether or not I expect to see that other places, I really don't. Superintendent Walters, to be pretty candid on what is a public and recorded event, is doing everything he can to get out and get media. He's been under a lot of scrutiny in general from the public because he used state funding to hire basically consultants to get him on the media, and their job was to book him on as many media appearances as possible. He has failed to get the state basic grants because he didn't want them coming from the woke federal government, is basically what he said. So he is basically just trying to become kind of a culture warrior. And I think that was one of the many steps in that process. So it's not something I really expect to see replicated in other states, to be totally honest. But to move through a little bit more of, oh, actually, that was all of my religion schools things. So I'm going to go back to the question from Becca, which says, are voucher programs an issue where we see high policy polarization between red and blue states? And the answer is absolutely yes. So we are moving back to vouchers a little bit here, but the short answer is voucher programs are not passing in states controlled by Democrats. They are passing in states controlled by Republicans. And they're not even actually passing in states controlled by Republicans all the time. So there was a big wave in 2022 and 2023. There was a Supreme Court decision that came down that essentially made voucher programs easier to pass and harder to challenge. And we saw a big wave of states do that. In Iowa, for example, I think it was last year. Well, in 2022, the Iowa governor helped primary against a lot of Republicans who opposed vouchers and got them replaced by Republicans who supported vouchers. And then within about 3 weeks of the start of the session in 2023, the state had enacted a voucher program. So we're seeing that happen a lot, because you might think, okay, vouchers are a Republican priority, and that is true. But there are a lot of Republicans who oppose vouchers, especially from rural districts, because vouchers don't benefit rural districts or rural students because there aren't private school options there. Maybe there will be one private school for elementary school students, or maybe there's one high school, but there aren't a lot of options. And so, or there may be no option. There may be no private school options whatsoever. So if you live in a rural area, vouchers aren't useful to you. And if you are a representative from that area, vouchers are not useful to your constituents. All they're going to do is drain money from the public schools, which not only are the school actually educating your children, but often are a big employer in the community, are a meeting ground for people who come to the community, right? They host events, they host public events, are places where people come together. You think about how important football games are in a lot of states, right? Like high school football games. I remember when I was in high school going to the football game and that being a big social thing. But it's not just the students, right? It's the community members who come around. It's the parents. It's people who want something to do on a Friday night. So public schools are really integral to rural communities. So a lot of Republicans oppose them. There also are a lot of Republicans who oppose vouchers because they are not a good way to protect the public funds, right? They go to unaccountable systems. And so like there's often no oversight in how the funds are spent. There's no oversight in how students are doing. So a lot of Republicans oppose these policies. And so they're trying to be pushed out by people who are more conservative and really support them. And they're backed, unfortunately, by a lot of money from people like the DeVosses and the Kochs who support voucher programs. And so we're seeing that happen a lot electorally where they are getting replaced. But yes, it is a very polarized issue. And I think is going to create a really stark difference between states that have statewide voucher programs and how they're gutting state budgets and those that don't. Okay, so if there are no other questions, or actually, I'll stop now to see if there are any questions about religions in school from the room, because I know that's often a topic that is of particular interest to AU members, quite understandably.
Nick, this is Ayman. I do want to just point out in Georgia, we do have a historical documents law, which allows a private donor to pay for a specific set of plaques to be erected in any government building. And these plaques include the 10 Commandments, and it's all on the false historical assertion that these documents, which are invariably chosen because they mention God in them, are essential to the founding of the United States Republic. So we are, and these documents are in both the Richmond County Courthouse and the Columbia County Courthouse. So if y'all ever go into either of those buildings, you can see them. So anyway, so this is a little bit of a problem we have.
Yes. Yeah. And there is honestly, there's essentially a constitutional difference between putting them in public buildings versus putting them in schools. So one, I will say that the law in Georgia the bill in Georgia that was proposed would have actually amended a similar law that applies just to schools. So there's a foundational law that says that schools can hang a number of documents, which includes the preamble of the Georgia Constitution, the Declaration of Independence, the Bill of Rights, the pledge, the motto. There's a lot of things in the list, and this would have added the 10 Commandments to that list. So it sounds like there is a parallel version for public buildings. So essentially there is separate Supreme Court precedent that says 10 Commandments displays in public buildings are constitutional under certain circumstances. There's a test essentially you have to meet, and it sounds like honestly just posting plaques that someone donates would not actually meet that threshold, but there is kind of there's a hard fundamental constitutional bright line against putting them in public schools in a way that there is not in government buildings. I wish the law on government building postings was stronger, but it is a little bit weaker than schools. Whereas schools, there is a direct on point case saying there is no educational value to posting the 10 Commandments in public schools, and you just can't do it. So yeah, it is definitely something that is a problem. And a lot of times what people pushing these bills say is, oh, the 10 Commandments are in the Supreme Court, or they're in these government buildings, blah, 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 blah. But really the fundamental line and what the reason this line exists for the Supreme Court is that students in public schools are much more susceptible to what is put on walls than adults walking through a government building. And the kind of the nature of the endorsement that happens because it's a public school, showing it to kids is a little bit different than it being on on the wall amongst many other things in a government building where people are not there. People are not there every single day, whereas a student is in the classroom every single day. So there are some pretty fundamental constitutional differences between those two that make me cautiously optimistic that our case, if and when it reaches the Supreme Court, because it feels inevitable that it will reach the Supreme Court, will actually still go our way. I'm not going to hold my breath, to be totally honest. I don't trust this court to give us great decisions on anything in our issues, but it is enough of a difference, and this would really be a big leap in a way that I think even some of the more moderate, such as they are members of this court, would consider a little bit too far. Okay, so the last section that I'm going to get into here is what we call using religion to discriminate. And so that is kind of a big bucket of using religion as an excuse to discriminate against other people. So a lot of the things that you might have heard about, actually in South Carolina, we had a case up until recently where we were suing the state and the federal government because a government-funded foster care agency had turned away a client of ours who was a Catholic woman because she wasn't evangelical. She wanted to work with foster kids, and the, again, government-funded evangelical foster care agency said, no, you basically are the wrong kind of Christian, and so you don't qualify to work with kids. So the big thing we saw this year was an attempt to pass a RFRA, which it's a Religious Freedom Restoration Act. I don't know how many of you are familiar with RFRA, but essentially in the early 90s, the Supreme Court changed the way courts are supposed to look at religious freedom cases. So basically, when your religious freedom is burdened, the court in a 1993 case, Employment Division v. Smith said, as long as a law is neutral and generally applicable, it's fine. So basically, the way the law worked before that was if there was a substantial burden to someone's religious beliefs, then that government relation had to be narrowly tailored and part of a compelling government interest to be able to withstand scrutiny and have the law survive a constitutional challenge. The 93 case fundamentally changed, actually no, it's a 1990 case, I'm sorry. A 1990 case fundamentally changed the way that analysis happened and basically made it harder for people to exercise their religious rights. So there was a broad coalition of groups, including AU, and it was a bipartisan coalition, and groups who would everything coming together that came through and convinced Congress to pass the Religious Freedom Restoration Act, which was meant to provide essentially heightened but not unlimited protections for people's religious freedom. So it was going to restore the old test that existed. Unfortunately, what happened starting in the mid-90s was landlords who were renting out their properties realized that they could use RFRA to refuse to rent to gay couples or unmarried couples because it violated their religious beliefs. And so since that happened, RFRA has really come to be used as a sword instead of a shield, right? It was meant to protect people's religious rights. So the kind of a classic example we use is if you work for a government agency and there is a uniform requirement or a dress requirement that says you can't have a beard, for example, ignore that I have a beard. There are religions that require you to have a beard. So if you are Sikh, you have a religious obligation to maintain a beard if you are a man. So a Sikh would not be able to comply with that dress code. So RFRA essentially would allow him to get out of that requirement because he's exercising his right. It's a substantial burden on his religious beliefs. And they don't really have, there's not a huge justification for preventing the beards, right? As long as there's no health or safety risk, he can have a beard. So that's kind of what RFRA fundamentally was meant to be about. But what it's being used for is primarily now is to undermine non-discrimination clauses. So if you have a non-discrimination ordinance in your city, and there is a for-profit corporation that wants to ignore that ordinance and say, I'm going to refuse to hire someone who's LGBTQ because it violates my religious beliefs, then a state RFRA would let them do that, essentially. So basically, my former colleague, Maggie Garrett, who, if you have worked in Georgia, you may know, because she actually used to do all the lobbying in Georgia. She previously worked and lobbied in Atlanta for the ACLU. Been fighting RFRAs in Georgia for certainly as long as I have been at AU and pretty much as long as Maggie has been at AU. And it really came very close to passing this year, essentially. There was an effort to pass a non-discrimination law, and the compromise was going to be putting in a RFRA provision in that law, essentially, to let that non-discrimination ordinance pass. Unfortunately, what that would do is just basically render the non-discrimination ordinance useless, because if you can use RFRA to get out of that non-discrimination ordinance, then there's no point of having it. So luckily that was kind of an ongoing discussion, and that the idea was to pass them as two separate bills. But we worked with the ACLU of Georgia, we worked with Georgia Equality we helped them develop talking points on why RFRA, or we have talking points on why RFRAs are bad, but we provided them those talking points to the groups in the state. There were rebuttals that were coming from that we provided because the sponsor of the bill had made a lot of claims, and so we helped rebut the claims. We offered alternative language, we offered amendments, and so we worked really closely with the groups fighting that bill, and were luckily able to help stop it from getting too much momentum before the legislature adjourned. But essentially every year they get kind of closer and closer to passing that RFRA, and we are, something we're going to continue fighting and definitely expect to see again next year. Is actually in the last, there were a lot of RFRAs, you may remember from 2015. RFRA really made the news in Indiana when Governor Pence signed a RFRA, and there was a lot of news around it because the NCAA was pulling out and conferences pulled out of the state. And so after that, RFRAs kind of stopped being a bill that people tried to pass, and they've unfortunately made a comeback since the pandemic. And Georgia is definitely one of the places where I think in the last 3 years, 4 or 5 states have passed a RFRA when no state had passed one since 2015. So it's been a big uptick, and definitely will be a fight in Georgia next year. So that is everything that I was going to cover. So if there are any questions, or whether about any of these bills, any other bills that are on the list that I shared, anything else you've heard about anything going on at AU, any questions you have, please throw them my way.
I gotta unmute here. Okay, go ahead.
I have a question. You said there are bills, you only covered the bills that the National AU was tracking. I'm at the local chapter, and I was tracking a South Carolina bill about transsexuals, minors, could not be treated medically. And that passed. Then there was one that was there a reason that the National didn't consider that a religious, state religion, bill?
Sorry, I could not hear the question. Are you able to repeat it?
Let me try. Actually, in Georgia and South Carolina, I know Georgia, but Stephen is reporting South Carolina. Legislation was passed to restrict certain types of medical treatments designed to do gender transition for minors. So, because you didn't talk about it, Stephen wondered, does Americans United consider that to be a separation of church and state issue?
Yeah, great question. So I guess there's a bit of a complicated answer. It is, right. It is certainly a church state separation issue in that the reasoning that people oppose that often is based in religion. And part of what we fight for, and I work on a lot of LGBTQ bills, we fight for LGBTQ rights in a lot of other ways. Essentially, we don't work on those bills unless there is an explicit provision in there that talks about someone being able to deny someone access to something or having a rationale for passing the bill that is religious. And the reason for that is, like I said at the beginning, I'm the only state policy counsel, and I'm already tracking 1,500 bills. And actually, usually we track those bills and pay attention to them. And so I work in a lot of coalitions nationally with LGBT organizations. I actually attend a weekly call of a lot of groups, not just LGBT groups, that work on those types of bills. But I just don't have the resources to devote there, because if I devoted a lot of time to those bills, I would not be able to devote as much time to things like the chaplains issue and the Ten Commandments issues and the vouchers issues, which there are lots of really great, wonderful organizations doing a lot of really great work to fight those bills that have a lot of the knowledge and expertise on that I don't have. And when they ask for my perspective on something, or there is that type of provision, I'm generally the person that they come to. So it really just is a matter of capacity. It's not that we don't care about that or oppose them. We just really don't have the ability to work on all of them. There are lots of bills there are even bills sometimes that we do have kind of, like I said, is a higher priority, right? So those are usually something we mark as a lower priority. So if it's happening at a time where I have more free time, maybe I can do something on it, or we can do outreach to our members. But more often than not, it's just something we don't have the capacity to work on, especially because there are so many other people who are doing that work. Whereas again, if no one were doing the chaplain work, there are groups there, but we've actually really led on that. So I'm not sure who would have picked that up or who would have had the slack to do that if we weren't doing it. So, a lot of the work that I do could end up being lost and not happen if we focused too much on a lot of issues where people are doing that work. It's kind of similar for a lot of the abortion work that happens. I do work when if there is something that says you can refuse to provide abortion healthcare because of religious beliefs, I will definitely engage in that bill. But if it's just a bill, or not just, I don't mean to say just, but if it's a bill that says we're going to ban abortions after 6 weeks, there's not an explicit religious component. A, again, there are lots of organizations doing that work, and B, I don't have the expertise on what a 6-week ban looks like versus a 15-week ban versus all of the provisions. So we just really, we have to consider our limited resources and capacity and prioritize our issues. And that is something that unfortunately we just don't have the capacity to prioritize too much on right now. Okay, so I see a few questions in the chat. I'm going to go to the second one from the anonymous attendee. What is the current status of the Do No Harm Act? Isn't this supposed to temper the negatives of RFRA? So great question. One, the Do No Harm Act is a federal bill that we support that would fix federal RFRA. So that, unfortunately, the bill was introduced and has, I don't remember the exact number of co-sponsors right now, but does have a high number of co-sponsors, if not equal to what it had in last Congress, nearly there. And we have been continuing to push for it. It's really our biggest federal priority. But unfortunately, we weren't able to get a hearing on it. We thought at some point we might actually be able to get a hearing on the bill, which would have been amazing. But that is something that we will continue to push on and takes a long time. Passing a bill takes a long time. We will continue to fight for that. So we definitely appreciate any support on that. But also part of the reality is that the Do No Harm Act would only fix federal RFRA, right? So RFRA was passed to apply to the federal government and the states, but a subsequent Supreme Court decision said that the Congress could not enact it on states. So states have passed their own individual RFRAs. And so we would need to essentially pass many versions of the Do No Harm Act in states if we wanted to fix those. But the states where RFRAs exist right now and are being abused really are in states where we would never have the chance to pass that type of bill.
Nick, regarding the third question, I hope Elaine might correct me. But I think MUSC stands for Medical University of South Carolina, right? Am I correct on that?
Yes.
Okay, so
Yes.
so if and there she posted in the
Yes, I see that now. I had not seen that.
Yep. Vanderbilt.
Yeah, I had not seen that, but I will definitely take a look at that and see how we might be able to, what the situation is there. So thank you for bringing that one to my attention. And then there's a question about another question in the chat. The recent decision for O'Connor, Radcliffe v. Garnier and Lincoln v. Freed seems to have given politicians expanded ability to block their constituents on the limited public forums they create in Facebook. Doesn't seem attorneys wish to touch these cases now. Yes, so that is definitely something that is a complicated specific issue. I don't know these decisions off the top of my head, but I know one of them was, or there's I know that American Atheist has a case about being blocked by a politician. But yeah, I mean, the short version here is that the Supreme Court is not good on our issues in general, and they're just making things worse. Another thing they're really doing that's making things difficult is changing a lot of the standing rules and who has the ability to challenge things. So there was actually a decision on an abortion case. I think it was the I don't remember the name of the case, but it was the one where the doctors challenged the abortion law or the right to an abortion because it took away their ability to, or they thought they were going to have to treat more patients of failed abortions and took away their ability to enjoy babies. It was just really ridiculous set of facts. And so the decision was good for the abortion movement, but essentially they kind of limited standing. A lot of standing in our situation for those who are not lawyers. In order to bring a case, you have to have standing. You have to have been injured, have a particular injury to bring a lawsuit. And a lot of times we rely essentially on taxpayer standing, right? Because if there is some sort of government posting of religion, it's hard to specify a particular harm, right? You're not suffering, you're not losing money, you're not, it's the idea that government shouldn't sponsor religion, right? So essentially what exists is if you are a taxpayer and the government posts something, you have standing as a taxpayer to challenge that religious posting. And the court has really been using standing to narrow what people have access to the Supreme Court in a way that is concerning, and certainly letting politicians block and ignore their constituents on very commonly used forums is a concern as well.
Any questions in the audience?
Your initial chart you had, there was one positive. What was the positive one that passed?
So it didn't pass. It was, what is it? Oh, there was a bill it was a bill in Georgia. Let me just pull it up quickly. Oh, so it was so that was actually the non-discrimination law that was going to be paired with the RFRA. So while we would support the non-discrimination law, we would not, of course, support pairing it with the RFRA. But the bill as introduced was one that we would support. And so it too did not pass before the legislature adjourned.
Right. Are there any other questions in the audience? Okay, and this is gonna be our last call for questions from the remote attendees. All right, and Nick, if you have anything that you're liking to promote from Americans United, please, it's a good time for you to do that now.
Yes. So first, if you are not a member, you can, or you're not on our email list, I just put a link in the chat, but you can go to au.org. We timed things right on the internet and got au.org, which is kind of amazing, especially as someone in DC where there's American University and all these other places that would love that that domain. So you can always go to au.org to learn more about AU and sign up to become a member, get our emails, stay aware of things. I also wanted to highlight that on July 20th, which is in 10 days, there's going to be an event called Unmasking Christian Nationalism. I just put the link for that in the chat as well, but you can find that you can find that on the AU website again under events. And so that is going to be a discussion with our president and CEO, Rachel Lazar. She's going to be having that with Dr. Samuel Perry, who is a professor of sociology at the University of Oklahoma at Norman, and Reverend Dr. Lori Walke, who is on AU's Faith Advisory Council and is a senior minister at a church in Oklahoma City. And so they're just going to be talking about the importance of church-state separation and really the fight against Christian nationalism. We picked Oklahoma as the venue. There is going to be an in-person event, but it will be live streamed as well. So you are all able to register and attend. And Oklahoma is really a center of a lot of the fights that are happening right now. Not only is that that issue that was brought up earlier of the superintendent of public instruction having that Bible directive for public schools, but the state actually passed a bill this year to allow release time programs in the state. And so those are essentially programs that let students leave public schools to go during the school day to attend get religious education at an off-site religious school, essentially. And also we have a lawsuit there where we are suing to stop the first religious charter school. So I talked a lot earlier about public schools versus charters, or traditional public schools versus charter schools. We kind of knew this was going to be the new frontier, but essentially a Catholic organization applied to get a charter, and in their application said that they were going to operate as a Catholic school, meaning that they would have admissions requirements on students, and they would have to sign a code of conduct to, not, again, be LGBTQ, they could be expelled if a student got pregnant, but also if they had LGBTQ parents, but also it would apply to teachers, right? So they could refuse to hire teachers who did not comport with Catholic values, and they would incorporate Catholic values and teachings in school. The students would have to attend mass. And again, this would be a public school, so it would be funded entirely by public funds. They would get the per pupil allocation. So Oklahoma has really been a place where we've been fighting this. So that is why that is the basis, but that will be happening, as I said, on July 20th. And then lastly, we do have our annual conference, the Summit for Religious Freedom, which I don't know that the exact dates are picked yet, but it will be happening sometime in April 2025. And you can go to thesrf.org to look at what happened this past year's conference. And if you monitor that website, you can find out more. So again, thank you for having me. And I hope this was...
Let's see if I can get, oh, there we go. Say hello to Nick. Say thank you, Nick. Thank you. And I hope the